Again, my name's Arthur Ketchturians, Carey Caruso. Carey's been doing criminal law for the last 28, 20, 30 years. His family's probably been in the business of criminal law. His brother's a criminal attorney. His father was a criminal attorney. He's been probably over 100 years of experience. With that, I think that's a good way for him to give us an introduction of the criminal system. Go ahead.
Thank you. Good evening, everybody. I don't know, about 100 years, that's what we're here tonight to talk about the criminal justice system as it exists primarily in Los Angeles County. If you practice criminal law in Southern California, you're going to inevitably be drawn into, we're a multi-county jurisdiction. You know, you're going to get called to Orange County and Ventura and San Bernardino, probably. But our emphasis tonight is primarily with emphasis on LA County. LA County is a unique situation because of its vastness and its diversity. Whereas Ventura County has one courthouse, Orange County has 4 courthouses, Los Angeles County has 30 criminal court. You could wind up on any given day, go to one of 30 criminal courthouses in LA County. There's an assumption here tonight between the two of us that the criminal knowledge here is fairly minimal, that your expertise lies in other areas. We're talking, it's hard to cover an entire area of law in an hour and a half. So we're being kind of general here, and we're trying to, just touch on the important spots so that you know what you're looking at when you see it. The court system, or the law game here, is really broken down. There's 2 courts, the civil court and the criminal court. Each of those have their varied delineations, but that's it. And in our constitutional frame, criminal matters, when pressed, will take precedence over civil matters. You're seeing that happen now in Riverside, where the court crunch with an obstinate district attorney is forcing civil matters to go on the back burner, where they try to take care of a backlog of criminal matters. We had that problem here years ago. But the criminal court system here, when you go to civil courts, more and more you see the separation between the criminal court and the civil court. There's still a few courthouses where you'll see defendants and even custodies coming through the hallways on their way, and they commingle with the civil. But more and more, the LA County system has built separate, distinguishable criminal courthouses, and has a separate presiding judge. It really has a whole separate administration apart from the civil courts. It's really an incredible system, and it works remarkably well for us, complex as it is. Anyone who's charged with a crime can only be charged in 3 particular areas. It's either an infraction, a misdemeanor, or a felony. That's all anything can be. An infraction, is pretty much, you don't have a right. A lot of your rights are not necessary with an infraction. It could be anything from a traffic ticket to this some certain marijuana laws, and a lot of things are infractions. Where you have a right to counsel and constitutional guarantees kick in is if you're charged with a misdemeanor. And a misdemeanor is anything that carries punishment with it that can be a year in jail or $1,000 fine. That's the maximum that they can do to you with regards to a misdemeanor, unless the legislature has mandated a higher figure. But it can't mandate a higher term in jail. Anything that has exposure in it, where you can be incarcerated for a period of time beyond a year, and in California that minimum term is 16 months, is a felony. Now, the system is structured. You can be charged with a felony, a misdemeanor, and certain cases certain crimes are what they call wobblers. That is that they can be filed as a misdemeanor, or they can be filed as a felony, dependent on the gravity of the crime. For an example, domestic violence, 273.5 of the Penal Code will delineate that it can be filed. You can be punished by a year in county jail or state prison. Any statute that delineates that the punishment is either a year in jail or state prison can be a wobbler. That is, it can be filed as a misdemeanor, filed as a felony, or ultimately can be, if you have to go out on the felony, you can come back and get it reduced as a misdemeanor if the guy satisfactorily completes, and we'll talk about that later on. But what will happen here is that there's an arrest, you know, there's always police contact here, some kind of police contact, whether it's an arrest or an investigation. And there's a requirement that the policing agency then turns over their investigation to a prosecutor. The police, people have a mistake that police have more input than they do with regards to the criminal prosecution. What they are scribes and collectors of facts at the beginning of the case. They turn over all of their information and all their stuff over to the prosecutor. Now, that would usually be on all felonies. Of course, it's the district attorney. The district attorney in the County of Los Angeles prosecutes all felonies. The city attorney of the City of Los Angeles prosecutes all misdemeanors in the City of Los Angeles. All misdemeanors that are prosecuted in the unincorporated areas of Los Angeles are, for the most part, conducted by the district attorney's office. So the district attorney office can actually be prosecuting misdemeanors in certain courthouses. For example, Beverly Hills up the street. It's in an unincorporated part of LA. The district attorney's office handles both the misdemeanors and the felonies. Downtown, which is in the city of LA, for example, city attorney runs all the misdemeanor courts, and the district attorney runs all the felony courts. So, but what will happen is the police will turn over their information to a prosecutor. If they think it's a felony, they will turn it over to the DA. The DA has filing deputies in every branch court, all these 20 or 30 courts. The district attorney has an office in all these courts. They'll turn over the information. That information, in turn, will be reviewed by a filing deputy. That, in fact, is a separate set of eyes. So it's not what the police think that you should be charged with. It's not what the police think you did or this, that, and anything. They simply wrote out a report. It's up to the filing deputy to determine what can I get a conviction on. Not what the police think, but what do these, as a district attorney, believe I can get a conviction on. That's why a lot of times the police will write it dramatically and the filing will be a lot different. As a matter of fact, a great number of district attorney or felony arrests that are submitted to the district attorney are rejected by the district attorney. That's what they call a DA reject. And what happens is when it's kicked by the DA, then goes over to the city attorney's office. If it's in one of those City of LA areas, which is the majority of courts here, and then the city attorney reviews it separately and determines whether to file a misdemeanor or not. And a lot of times, things that were dramatic at the time, in the cool light of day, after a couple of days, you'll see a lot of felony arrests result in misdemeanor filings. And that puts your guy in a much shallower end of the pool than when he thought he was arrested. There's a great deal of emotional upheaval with all this stuff, especially at the initial arrest. You have a client who's extremely vulnerable, and has got a ton of issues. Those of you that do family law or in other highly emotional areas of the law, you know what I'm talking about. And dealing with a client emotionally has a lot to do with what we're doing here. So, we've got a great criminal justice system here in LA. It's massive and it's deep, but there's the police aspect of it. Then there's the prosecutor's aspect of it. Then you get the phone call. Then you get a call, or if somebody contacts you and says, "I'm in trouble. Can you help me?" All right, Arthur.